Are you a director of a limited company and unsure what decisions you can and cannot make? Well, stay tuned to find out. Hi there, Nicholas Cameron here from First Formations, the UK's leading company formation agent. Directors and shareholders have different responsibilities in a company, although the same people often hold both positions simultaneously. Shareholders typically make company decisions only in exceptional circumstances, while the board of directors has the power to make most routine decisions without shareholder consent. The rules on company decisions and directors' powers are set out in the Companies Act 2006, the Articles of Association, and sometimes, where applicable, a private shareholders agreement, directors' service agreements or contracts of employment, and resolutions passed by the company's shareholders. As a director, it is essential to check all these documents carefully to determine exactly which decisions you have the authority to make and which matters you must defer to the shareholders. So, let's get started with decision-making by directors. Directors are responsible for managing a company's day-to-day business. While performing any aspects of their role, they must adhere to the 7 general duties of directors as specified in the Companies Act 2006, sections 171 to 177. They are to act in accordance with the powers they are granted by the company's constitution and only exercise those powers for the purposes for which they are conferred, seek to promote the success of the company for the benefit of its members as a whole, exercise independent judgment, exercise reasonable care, skill and diligence, avoid conflicts of interest, not to accept benefits from any third parties, and declare interest in any proposed transactions or arrangements with the company. The Articles of Association is a constitutional document that sets out the particular rules of the company, including director decision-making powers. So, you'll find a lot of the provisions relating to what decisions directors can make and how in here. In many companies, a private shareholders agreement is also drawn up to provide additional protection to members, including the level of authority the directors have to make company decisions without their consent. So, what are the common types of company decisions that directors can make? Under the Model Articles of Association, which most new and smaller companies use, directors have the authority to make any decision other than those expressly prohibited by the Articles, a shareholders agreement, their service or employment contracts, or resolutions of the members. This means the board of directors usually has the power to make the following types of company decisions without shareholder consent. Day-to-day management decisions, matters relating to routine financial and accounting activities, choosing suppliers and accepting new clients, entering the company into legally binding contracts with third parties, strategic and operational decisions, HR-related activities, including the appointment of new directors, implementing company-wide policies, approving share transfers, declaring interim dividends, recommending final dividend amounts to be declared by shareholders, final dividends being those which are usually paid at the end of the financial year after the accounts have been approved, authorising a change of registered office address, appointing a company secretary, engaging accounting and legal services for the company, and appointing the company's first auditor, or the first one after a period of audit exemption, and filling a casual vacancy for the role. On all such matters within their remit, the board must exercise their decision-making powers collectively. However, in areas where individual directors have expertise over others, they may have the authority to make certain decisions without consulting the rest of the board. If you are the sole director of the company, you are responsible for making decisions relating to the company's affairs on your own. So, those are the types of decisions directors can usually make. Let's now break down the procedure for making those decisions. The board of directors must make company decisions at board meetings or by written resolution in accordance with the rules and procedures set out in the Companies Act 2006 and the Articles of Association. As per the model articles, the general rule is that directors can make decisions by majority agreement at a board meeting or by unanimous agreement in writing. These types of formal decisions are known as resolutions. Written resolutions are becoming increasingly common due to their flexible nature. It's often more convenient to make decisions this way rather than having to arrange and convene at meetings. However, for many company decisions, directors can greatly benefit from discussing, debating, and voting on proposed actions at board meetings, whether they are held in person or remotely. Let's take a closer look at these two decision-making methods. Please do bear in mind that this information applies if your company has adopted the model articles in their entirety. The rules may differ if your company has modified model articles or bespoke articles, so do be sure to check. So, firstly, board meetings. To vote on a proposed resolution at a board meeting, you must call the meeting by giving notice to all eligible directors. No statutory notice period is required, and it doesn't actually have to be in writing. However, the notice must include the proposed date and time of the meeting, where it's taking place, and the means of communication during the meeting if the participating directors are not going to be in the same place, for example, via video conferencing. A quorum must be present for directors to vote on any proposed actions at the meeting. The required quorum is 2, unless a higher number is specified in the articles or by previous board resolution. To vote on a proposed resolution at a board meeting, the directors cast their votes. If more than 50% of the directors vote in favour of the motion, the board resolution is passed. The decision is then legally binding. Then we have decisions by written resolution. A written resolution enables directors to vote on the proposed action in writing rather than at a meeting. However, you can only pass this type of written resolution with unanimous agreement from all directors. This means that all directors eligible to vote must be in favour of the motion, otherwise it cannot pass. You can circulate directors' written resolutions and voting instructions on paper. Each director can then sign the document to indicate their agreement. Alternatively, you can distribute and vote on proposed written resolutions via electronic means. For example, by email or even on a website. If you pass a board resolution at a meeting, you must record the decision in writing in the meeting minutes. Copies of any board meeting minutes or written resolutions must be kept for at least 10 years. Now, let's talk about which company decisions require shareholder consent. Under the Companies Act 2006, the most significant decisions affecting a company are usually reserved for the shareholders. Unless otherwise stated in modified or bespoke articles or shareholders' agreement, the following are examples of company decisions that require shareholder approval by ordinary resolution, which requires more than 50% of the votes to be cast in favour. Removing a director from office. Declaring final dividends up to the amount recommended by directors. Changing the directors' powers. Approving substantial property transactions, authorising the directors to issue more shares, approving a director's loan, approving a director's service contract with a fixed term that exceeds 2 years, ratifying a director's conduct where it amounts to negligence, default, breach of duty, or breach of trust in relation to the company, approving a purchase of own shares, that is, a share buyback out of distributable profits, and appointing auditors. Next, we have some company decisions that require shareholder approval by special resolution, which requires 75% or more of the eligible votes to be cast in favour. These include amending the company's articles of association, changing the company name, reducing the company's share capital, creating a new share class, disapplying shareholders' pre-emption rights upon the issue or the transfer of shares, purchase of own shares out of capital, and approving company re-registration, for example, from a private limited company to a public limited company or vice versa. As before, the rules on company decisions may differ in companies with amended or bespoke articles of association. For instance, it may be the case that certain shareholder decisions typically passed by ordinary resolution require approval by special resolution instead, a higher majority vote, or even unanimous agreement of all eligible members. Furthermore, some companies may restrict directors' powers beyond those set out in the model articles, while others may grant the board of directors additional decision-making powers. This is why it is crucial to fully understand your company's articles. By doing so, you can ensure that everyone is acting within their powers and adhering to the prescribed procedures specified in the company's constitution. So there you have it. Exactly which decisions directors can make without shareholder consent depends on the company's articles of association. You must also check any shareholders' agreements, directors' service or employment contracts, and previous resolutions to determine the extent of directors' decision-making powers. If you have any questions about this video, please comment below. We also have included some useful links in the description. Alternatively, you should contact a commercial solicitor for expert advice on resolving decision-making issues in your company, drafting bespoke articles of association, or drawing up an effective shareholders agreement. And finally, be sure to subscribe to our channel to get more tips and advice on limited companies, reporting requirements, tax obligations, and more. We're always happy to help, and we can't wait to hear from you. Until next time, cheerio.